In the heart of medieval Tortosa, a city brimming with the promise of a new era, a chilling decree hung over the lives of its citizens. The air was thick with the scent of freshly baked bread and the distant clang of blacksmiths, but the shadow of the law loomed large, casting a dark and ominous presence over the cobblestone streets. The city's ordinances, carved in stone and inked on parchment, were a stark reminder of the power held by the municipal government and the severe consequences of defying it. Among these laws, the threat of the death penalty stood out, a final and irreversible punishment for those who crossed the line. The rise of bourgeois elites in Tortosa marked a significant shift in the city's power dynamics. These new leaders, driven by ambition and the desire for control, began to monopolize authority, taking over the power to impose the most extreme penalties. The death penalty, once a rare and solemn act, became a tool to maintain order and suppress dissent. It was a clear message: the city's power was absolute, and those who challenged it would face the ultimate consequence. The city's ordinances, meticulously recorded in the Costums de Tortosa, detailed the graduated punishments for various crimes. Theft, for instance, could result in a range of penalties, from public humiliation to the loss of limbs, and ultimately death. For example, a thief caught stealing a significant amount could be sentenced to run through the city naked, branded with a hot iron, and have his ears cut off. If the theft was of a more substantial value, the punishment was even more severe. The right hand could be amputated, and for the most egregious cases, the thief would be hanged. But the law did not stop at theft. Other crimes, such as plotting against the prince, engaging in sodomy, or committing murder, were met with equally harsh penalties. A person who planned to assassinate the king or his heir was to be executed, and those who engaged in homosexual acts were to be beheaded. Murderers, if caught and convicted, faced the gallows, their bodies left as a grim warning to others. The city's laws were not limited to its Christian citizens. Jews and Muslims, while often treated differently, were still subject to the death penalty under certain circumstances. For instance, if a Jew or Muslim was found having sexual relations with a Christian, the non-Christian was to be flogged and hanged, while the Christian woman was to be burned alive. However, if the woman was forced or misled, she could be spared, but the non-Christian would still face severe punishment. The city's ordinances also addressed the issue of slavery, a common practice in medieval Tortosa. Slaves who attempted to escape faced brutal consequences. If a slave was caught fleeing, they could be flogged and hanged, especially if they were of Islamic origin. Christian slaves, while still subject to harsh penalties, might be hanged without the additional flogging. The city's leaders were determined to maintain control over the enslaved population, and the laws reflected this ruthless determination. The threat of the death penalty extended to other areas of life as well. For example, the use of poisons was strictly forbidden. Anyone caught selling or administering poisons, even for medicinal purposes, could be hanged without mercy. The city's leaders were particularly wary of the potential for poisoning to be used in political or personal vendettas, and the laws were designed to deter such acts. The city's ordinances also aimed to maintain social order and prevent violence. For instance, anyone caught entering another person's home by force, whether during the day or at night, could be executed. The same applied to those who engaged in brawls or riots. The city's leaders understood that maintaining peace and order was essential for the prosperity and stability of Tortosa, and they were willing to use the death penalty to achieve this goal. The city's laws were not just a collection of harsh penalties, they were a reflection of the power and authority of the municipal government. The threat of the death penalty was a powerful tool, one that the bourgeois elites used to assert their control over the city and its citizens. In the streets of Tortosa, the weight of these laws was felt by all, a constant reminder of the price of defiance. As the sun set over the city, casting long shadows across the market squares and narrow alleys, the people of Tortosa went about their daily lives, ever mindful of the laws that governed them. The threat of the death penalty hung over their heads like a sword, a stark reminder of the price of transgression. In the heart of medieval Tortosa, the law was the law, and the consequences of breaking it were dire. In medieval Catalonia, the death penalty was a serious matter that followed strict legal procedures. It wasn't something that could be handed out arbitrarily. According to King Peter the Ceremonious in 1359, any death sentence had to be based on either civil law or local customs. This meant that the law had to be followed precisely, and the sentence had to align with the usages de Barcelona, usages of Barcelona, constitutions, privileges, and customs of Catalonia. The courts also had to consider equity and good reason in their judgments. When applying the law, the accused person had to be given full legal defense. King Alfonso the Kind made this clear during the general courts in Montblanc in 1333. He ordered that no one should be condemned to death, mutilation, or torture without being given a fair chance to defend themselves. He emphasized that any judgment that did not follow these rules would be invalid. The legal process in medieval Catalonia was based on the Romanist model, which was well established by the first half of the 13th century. Despite the fragmented jurisdiction, the basic forms and procedures in the courts were consistent throughout the region. This consistency showed that the legal system had a common culture and was supported by notaries and jurists who were trained in similar institutions, known as studium generale. The courts required that anyone working as a lawyer, judge, or legal advisor in the cities, towns, and other notable places must have a solid education in the law. Specifically, they needed to have the 5 ordinary books of civil law, or at least the ordinary books of canon law. They also had to have studied these subjects for several years in a studium generale. The legal system in medieval Catalonia was designed to ensure that justice was fair and that the rights of the accused were protected. This meant that the death penalty could only be imposed after a thorough and fair trial, following the established laws and customs of the region. The emphasis on legal education and the requirement for a fair defense were crucial in maintaining the integrity of the judicial system and ensuring that justice was served. In the medieval Catalan justice system, the district and local courts were organized similarly. The primary official, who held delegated jurisdictional power, was usually assisted by another official who could step in with full authority when needed. This assistant was known as the subvicar, who could help or replace the vicar. The main official would be supported by a judge, a legal assessor, a fiscal procurator, an advocate for the poor, and a scribe who documented everything along with their assistants. Sergeants were responsible for carrying out the court's decisions. These courts handled a wide range of tasks, from registering loans and issuing safe conducts to authenticating documents and maintaining public order. They also investigated, pursued, and punished crimes and offenses. The process began when an offense was reported. The official in charge would then take action, often visiting the crime scene with assistants to gather evidence. They would interview witnesses, sometimes using pre-prepared questions, to learn more about the incident and identify suspects. If a suspect was identified, they would be summoned to appear before the court. If the accused did not show up, they would be declared outlaws. The official would call the suspect multiple times, but in practice, these calls were often combined into one. If the suspect still did not appear, they could be arrested by anyone who found them, as announced publicly. However, the reality was that the jurisdictional landscape was highly fragmented. This made it easy for suspects to flee to neighboring jurisdictions where they could find refuge. Local lords generally did not hand over suspects from other jurisdictions to avoid setting precedents of submission. This led to a system of mutual impunity, where suspects could easily escape justice. To address this, cities like Barcelona and Tortosa developed strategies. They would sometimes mobilize the urban militia, known as the Sumtent, to reclaim suspects from other jurisdictions. For example, in 1391, a fugitive who had taken refuge in Martorell was seized by the local lord and executed. In other cases, negotiations were enough. In 1398, Barcelona negotiated with the Viscount of Cabrera to capture a man who had killed someone's wife. The elite families in urban centers often held jurisdictional rights over the surrounding rural areas, leading to conflicts over jurisdictional authority. For instance, the Despasque family, who were royal civil servants, acquired the towns of Saint Vicent and Vilassar, north of Barcelona, and gained full jurisdiction. This led to tensions and even military confrontations, but also to agreements for collaboration and the exchange of suspects. Similar agreements were made in other powerful municipalities. Tortosa, for example, signed agreements with the military order of Montesa in 1379, the royal town of Montblanc in 1402, and the Count of Cardona in the 15th century. These agreements allowed for the extradition of suspects between jurisdictions. Despite these efforts, jurisdictional fragmentation meant that outlaws were a common part of daily life. They could find refuge in other jurisdictions, leading to a cycle of impunity. The king, Peter the Ceremonious, even offered protection to those fleeing from baronial jurisdictions to increase the population in royal towns like Villafranca del Penedès and Cervera. In 1382, he promised to protect anyone who was on the run from baronial jurisdictions. This approach, however, had a flip side. Those pursued by royal officials could simply seek refuge in other jurisdictions. The king responded by promising to give refuge to delinquents who had committed crimes in lands under other jurisdictions. The lack of collaboration between jurisdictions made it difficult to enforce laws and recover debts. For instance, in the town of Igualada, surrounded by the jurisdiction of the powerful Viscount of Cardona, criminals could easily flee to the Viscount's territory and escape justice. If someone accused of a serious crime was arrested, they would be held in prison. Local privileges often prohibited imprisoning local residents, except in cases involving the death penalty or mutilation. Trials were conducted with Romanist guarantees and procedures, involving the accuser and the defendant appearing before the court. The accuser, often a private individual or a fiscal procurator, would present charges, and the accused would receive a copy to prepare their defense. Witnesses would be called and interrogated, and their testimony would be recorded. Public reputation played a significant role in trials. A bad reputation could be used as evidence against the accused. In some cases, public fame alone could be enough to justify torture or even a conviction. For example, in 1424, it was ruled that if it was widely known that the accused had committed a murder, this could be sufficient evidence for torture or conviction. If the accused refused to admit guilt, the prosecution could request torture. The judge would decide whether to grant this request based on the evidence presented. Torture was not commonly used, and it was often restricted by local privileges and the status of the accused. For instance, in some towns, torture was prohibited, and it was rarely applied to nobles and barons. This complex system of jurisdictional authority, with its fragmented and often conflicting jurisdictions, shaped the administration of justice in medieval Catalonia. Despite the challenges, efforts were made to ensure that justice could be served, even if it often fell short due to the fragmented nature of the region. In the legal system of the 14th century, the trial process was designed to be fair and balanced, giving each party a chance to present their arguments. However, this approach often made the process longer and more complex. Judges had to be very careful and objective, and the parties involved needed to trust their lawyers, who were well trained in the law. Despite this, the system wasn't always perfect. In 1351, King Peter the Ceremonious of Aragon recognized a significant problem. Many poor people were being denied justice because of minor legal errors. He ordered that judges should not dismiss cases, just because of small mistakes in the formalities. The idea was to ensure that the intent behind the claim was clear, even if the form wasn't perfect. Despite these efforts, the legal system still faced criticism. Francisc Aiximines, a prominent figure in the 14th century, argued that lawyers were often expensive and sometimes prolonged cases to make more money. He also accused them of using harsh tactics to win, even if it meant destroying the other party. This led to a growing distrust of lawyers, and there were calls for fewer but better quality lawyers to serve the public. The complexity and expense of the legal system were significant issues. People began to blame lawyers for making the system slow and ineffective. In response, the courts in the 1430s tried to simplify the legal process by clarifying the order of precedence for laws and customs, aiming to reduce disputes and speed up the judicial process. When a trial ended, one party, usually the prosecution, would request a verdict. The judge or a jurisdictional official would then set a date for the reading of the sentence. In a formal setting, the judge would review the evidence, invoke God, and deliver the verdict. If the accused was found guilty, a punishment would be decided, ranging from fines to capital punishment, depending on the crime. This process was similar in both royal and baronial courts. though there were some differences. In baronial courts, a bailiff often replaced the prosecution, and in ecclesiastical courts, the influence of legal assessors was sometimes limited. The rise of municipalities also had a significant impact on the legal system. In the newly incorporated southwestern lands, cities like Cervera, Tàrrega, and Tortosa gained more power. Local juries and prominent citizens, prohoms, played a crucial role in judicial actions, especially in smaller towns. In these places, the juries and prohoms could participate in investigations and trials, even if they couldn't impose capital punishment. In larger cities, such as Barcelona, the municipal government insisted on its right to participate in the legal process. Barcelona's representatives complained to the king in 1350 about the lack of local involvement in investigations. The city had a privilege that required 2 local prohoms to be present during inquisitions. This was formalized in the Recognovant Procers, a set of privileges granted by King Peter the Great in 1284. In Tàrrega, Prince Martin confirmed in 1383 that only the bailiff and the local council could exercise judicial power. Similarly, in Valls, local officials were reminded that they could not hand down sentences without consulting the prohoms, as was the custom. This local involvement helped to strengthen the power of urban centers over their regions. For example, the city of Lleida claimed the right to judge crimes committed in distant areas like Pallars, demonstrating its influence. In 1485, a woman from Sass, accused of witchcraft and murder, was tried and sentenced to death by the prohoms of Lleida. The moral status of the accused was also considered. In 1399, a court in Lleida judged a Flemish man who was robbed in a neighboring kingdom, showing the city's firm judicial power. In Tortosa, local authorities insisted that any crime committed within the city limits, regardless of where it happened, should be judged by the local prohoms. The power of local authorities sometimes led to conflicts with the king. In 1400, King Martin the Humane had to accept Tortosa's refusal to pass cases to the royal courts, even for the protection of widows and the poor. However, the king prevented local officials from reviewing capital and corporal sentences in 1360. In Tarragona, the 1312 concord between the king and the archbishop favored the archbishop, who had the final say in appeals. This highlighted the importance of the prohoms in deciding cases. The demand for the high bourgeoisie to be treated like the lesser nobility was another significant issue. By the end of the 14th century, the Council of Barcelona tried to address urban violence through local ordinances. If a baron or an honorable citizen was condemned to death, they would be decapitated. For other members of the urban estate, the punishment was hanging. These changes and interactions between local and royal authorities shaped the legal landscape of the time, emphasizing the growing power and influence of municipal government. The intricate history of justice in medieval Barcelona reveals a city deeply engaged in the struggle to maintain its judicial autonomy. The city's unique system of jury de prohoms, or trial by eminent citizens, was a cornerstone of its municipal identity and a source of frequent conflict with royal and feudal authorities. This system allowed the city's leading citizens to judge criminal cases, a privilege that Barcelona fiercely defended throughout the 14th and 15th centuries. In the mid-14th century, the city faced significant challenges as the crown sought to centralize its authority. King Peter the Ceremonious, for example, confirmed in 1363 that criminal affairs in Barcelona could only be judged by the city's jury de prohoms unless the king or his heir was physically present. This agreement reflected the delicate balance of power between the monarchy and the city. However, the presence of the governor of Catalonia, who often acted as the king's representative, frequently led to jurisdictional disputes. The governor's court, modeled on Roman law, began to encroach on the city's judicial powers, leading to tensions and protests from the city council. One notable incident occurred in 1486, when the governor, acting on his own authority, hanged a man on the city's gallows without consulting the local tribunal of eminent citizens. The city council vehemently protested, arguing that the execution violated their privileges and jurisdiction. This conflict highlighted the city's determination to protect its judicial rights and the gallows, which were symbols of its sovereignty. Similar disputes arose with the Royal High Court, which was established to hear cases in the king's name. In 1451, the the vice-chancellor of the court condemned a man to death, but the city councillors intervened, obtaining a stay of execution from the queen. The condemned man was taken down from the gallows, and the case was reviewed, ultimately leading to his execution, but on terms that respected the city's privileges. The city's efforts to maintain its judicial autonomy were not limited to conflicts with the crown. The city also had to navigate its relationships with other local powers, such as the barons and nobles. In 1445 and 1466, the jury de prohoms condemned knights to death, despite their protests that the city lacked the authority to judge them. These cases underscored the city's resolve to assert its judicial powers, even against the nobility. The system of trial by eminent citizens was not unique to Barcelona. In other cities like Tortosa and Lleida, similar arrangements were made to ensure local participation in the administration of justice. In Tortosa, for example, the vicar was accompanied by 4 peers and 2 judges, all chosen from the city's leading citizens. This system ensured that the local community had a voice in judicial matters, reflecting a broader trend of municipal involvement in the judicial process. The history of Barcelona's struggle to maintain its judicial autonomy is a testament to the city's resilience and the importance of local governance in medieval society. Despite the challenges posed by the crown and other authorities, the city's commitment to its jury de prohoms system endured, shaping the legal and political landscape of the region. This story of jurisdictional conflict and local resistance provides a rich and nuanced understanding of the complex dynamics of power and justice in medieval Catalonia.